This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about the insurance adjuster, and specifically the insurance adjuster who deals with first-party property claims. The insurance adjuster is not mentioned in a policy of insurance. The obligation to investigate and prove a claim falls, by the wording of the policy, on the insured. Standard first-party property insurance policies based on the New York Standard Fire Insurance Policy contain conditions that require the insured to, within 60 days of the loss, submit a sworn proof of loss to prove to the insurer the facts and the amount of the loss. The policy allows the insurer to then, and only then, respond to the insured's proof of loss. The insurer can either accept or reject the proof submitted by the insured. Technically, if the wording of the policy was followed literally, the insurer could sit back, do nothing, and wait for the proof. If the insured was late in submitting the proof, the insurer could just reject the claim. If the insured submits a timely proof of loss, the insurer could either accept or reject the proof of loss. If the insurer rejected the proof of loss, the insured could either send a new one or give up and gain nothing from the claim. Suit on the policy would be difficult because the policy contract limited the right to sue to times when the proof of loss condition had been met. Insureds and insurers were not happy with that system. It made it too difficult for a layperson to successfully present a claim. The system as written in the standard fire policy seemed to run counter to the covenant of good faith and fair dealing that had been the basis of the insurance contract for centuries. Most insurers understood that their insureds were mostly incapable of complying with the strict enforcement of the policy conditions. To fulfill the covenant of good faith and fair dealing, insurers created the insurance adjuster to fulfill its obligation to deal fairly and in good faith with the insured, and to allow the insurer the ability to keep the promises made by the insurance policy. What is an adjuster? An adjuster, or insurance adjuster, or claims representative, is by statutory definition a person, a co-partnership or corporation that undertakes to ascertain and report the actual loss to the subject matter of insurance due to the hazard insured against. Insurance companies create, by issuing an insurance policy, a contractual obligation to pay its insured's valid claims. To do so, insurers understand that the person insured is usually not able to prove the cause and extent of loss without assistance. Therefore, insurers dispatch a person with special knowledge, the adjuster, to separate fact from fiction, to establish cause and origin of the claimed loss, and determine sufficient information to enable the insurance company to determine the amounts necessary to indemnify the insured as the policy promised. The adjuster is also present to distinguish the valid claim from a claim which the insurance company is not liable under its policy. Some policies specifically state that the claimant must use his own judgment in estimating the amount of loss, and the assistance of an insurance adjuster is a courtesy only. The claimant must still send a proof of loss within 60 days after the loss, even if the adjuster does not furnish the form or help the insured complete it. As a general rule, when an insurer gives its insured written notice of its desire that proof of loss under a policy of fire insurance be furnished and provides a suitable form for such proof, failure of the insured to file a proof of loss within 60 days after receipt of such notice, or within any longer period specified in the notice, is an absolute defense to an action on the policy. This was stated in Stopani versus Allegheny Co-op Insurance Company, a 2011 decision of the New York Courts of Appeal. Since the invention of the adjuster, more than a century ago, the first person from the insurer that the insured meets when he or she suffers a first-party property loss is the adjuster. The claim adjuster was invented to smooth the claims process and be certain that the insured receives the indemnity promised and performs a complete and thorough investigation to avoid fraudulent claims or claims that are simply not covered by the terms and conditions of the policy. Every modern claims adjuster should know that it is his or her duty to aid the insurer in its obligation to fulfill the promises made by the policy of insurance and assist the insured in presenting his or her claim to the insurer. An adjuster's duty to the insured do not arise from an insurance contract, because an adjuster is not a party to the contract, but for the adjuster to owe the insured a duty to act with reasonable care. A contractual relationship must exist between the insured and the insurer who is employing the services of the adjuster. An insurance adjuster is a person engaged in the business of insurance. The first-party property insurance adjuster limits his or her activities to the investigation and adjustment of first-party property claims like fire, lightning, windstorm, hail, theft, or other physical losses to property that is the subject of the insurance. Some statutes define an adjuster as one who investigates losses on behalf of an insurer as an independent contractor or an employee of an independent contractor or the insurance company. An insurance adjuster is an agent of the company, and his powers and authority are prima facie coextensive with the business entrusted to his or her care. The duty of the adjuster is to ascertain and determine the amount of any claim, loss, or damage payable under an insurance contract, and or effecting settlement of such claim, loss, or damage. The acts of an adjuster within the apparent scope of his or her authority are binding on the insurer without notice to the insured of limitations on his power or her power. This was stated in Florida in 1970 in a case called Old Republic versus Von Onweller. The duties and obligations of the property adjuster include, because there is a special relationship between an insurer and the insured, they are in privity of contract as an individual, and the individual insurance adjuster is not in privity with the insureds or the insurer based on the insurance policy wording. Thus, although the employee adjuster does not owe a special duty to the insureds on which the bad faith tort could be based against the adjuster, he or she owes the duty to the insurer-employer, although actions of the adjuster can support a claim for bad faith against the insurer for whom the adjuster works. To consider the California Supreme Court decision in Grunberg versus, or the 11th Circuit decision called Dumas versus ACCC Insurance Company, a 2009 decision out of Georgia, that found that in the absence of privity of contract, an insurance adjuster is not individually liable to an insured for failure to settle a claim against the insured, although the insured can still sue the insurer because of the actions of the adjuster. However, the actions of the adjuster can always cause the insurer that employed him or her to face charges of breach of the insurance contract and people who seek liability for breach of the tort of bad faith. Texas courts have noted that an adjuster is a person subject to the requirements of the Texas Insurance Code with regard to acts undertaken in the business of insurance. An independent insurance adjuster is not liable to an insured for malfeasance when the insurer delegates to the adjuster the responsibility to handle the insured's claim, because the adjuster is not in contractual privity with the insured. And therefore, in the Grunberg versus Aetna case going all the way back to 1973, the court held that the insurance adjuster and the law firm hired to deal with the claim were not liable for bad faith regardless of the egregious conduct of the adjuster. However, in Texas, the Texas Supreme Court has determined that the adjustment of claims and losses qualifies as the business of insurance, thus making an adjuster a person under the Texas Insurance Code that held that an insurance adjuster who services a policy engages in the business of insurance and therefore could be held individually liable under the Texas Insurance Code. Regardless of the jurisdiction, the adjuster must conduct himself or herself in such a way that there will never be an issue that the insurer breached the contract directly or through the adjuster's action. Although protected from individual tort liability in almost every state, an adjuster acting in bad faith exposes the insurer to a bad faith judgment and will probably cause the adjuster to lose his or her job. Imposed on the adjuster by the insurer and by state law and regulation is an obligation to investigate the loss, interpret the policy wording, and apply the policy wording to the facts discovered in the investigation. A first-party property adjuster must be educated, trained, experienced, and ready to help an insured obtain the benefits promised by the insurance policy. Unusually, in the state of Washington, in a case called Maun Keodala versus Allstate, a 2018 decision of the Washington Court of Appeals, the court found that an adjuster could be personally liable for tort damages incurred by an insured as a result of what the state found to be bad faith conduct. That case went up to the Washington Supreme Court, and fortunately for the adjuster involved, was reversed. This video was adapted from my book, The Compact Book of Adjusting Property Claims, 2nd edition, and is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you, please refer it to your colleagues. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn about future videos and blog postings. Thank you for your attention.